Where does a country's power actually end? Well, you'd think the answer is simple, right? It ends at the border. But in our world today, that's not so clear-cut anymore. That line on the map, it's getting pretty blurry. So in this explainer, we're going to dig into how international law even begins to tackle that question. I mean, we all kind of get this idea, right? A country's power stops at a physical border. But think about this. What happens when a cyber attack is launched from, say, one country to completely mess with the power grid in another? Or what about a terrorist plot that's planned on one continent but is meant to happen on a totally different one? All of a sudden, that simple line on the map doesn't seem so simple. Yeah, crime definitely doesn't respect borders, and that's exactly why international law has to get involved. All right, here's the plan for today. First, we'll look at that classic idea, a line on the map. Then we'll get into what happens when crime crosses borders. After that, we're diving into the 5 main tools of jurisdiction. Then we'll see what happens when those laws overlap, and we'll wrap it all up with something called the immunity shield.
Okay, let's kick things off with Section 1, a line on the map. This is all about the traditional view of a state's power.
First things first, let's nail down a super important term we're going to be using a lot: jurisdiction. I know it sounds a little legalistic, but it's really just a word for, well, power. It's the official power to make legal decisions and judgments. Basically, a country's right to make its laws, have its courts judge cases, and have its police enforce those judgments. And this quote, this is from a really famous case back in 1927 called the Lotus case. And it perfectly sums up the starting point for all of this. It basically established the #1 rule of international law. A state can't just exercise its power in another state's territory. Your power is absolute for sure, but it stops right at the border. You can't just send your police into another country to make an arrest. It just doesn't work that way. Okay, so that brings us to Section 2, when crime crosses borders. Because as we know, the world is way messier than that simple rule suggests. So let's look at how international law has had to adapt. So when we talk about a state using its jurisdiction, what does that actually look like? Well, it breaks down into 3 things. First, you have the power to prescribe. That just means making the laws. Think of your government passing a new law. Then you have the power to adjudicate. That's the courts, judging people based on those laws. And finally, you have the power to enforce, which is, the police carrying out the judgment. Now, all 3 are obviously crucial, but the one we're really going to zero in on is the first one, prescribing, because the biggest question is always, who gets to make the rules in the first place? And that leads us right into Section 3, the 5 tools of jurisdiction. Think of this as the legal toolkit countries use to argue, hey, our laws apply here. And trust me, this is where it gets really fascinating. So here are the big 5 principles. You've got territorial, nationality, passive personality, protective, and universal. Each one is a different reason a country can claim jurisdiction. Let's go through them. All right, tool number 1 is the territorial principle. This one's the most straightforward, the most common sense of them all. If something happens on your turf, your land, your sea, your airspace, you get to make the rules. Simple as that. But okay, what about a crime that straddles a border? Let's go back to that hacker. They're sitting in country A and they launch an attack that totally wrecks the banking system in country B. So, who gets to prosecute? Well, international law actually has 2 answers here. There's objective territoriality, which says country B gets jurisdiction because that's where the crime was finished and the effect was felt. But there's also subjective territoriality, which says country A also has jurisdiction because that's where the whole thing was started. And you can see how this subjective part is absolutely vital for dealing with things like cybercrime today. Next up, tool number 2, the nationality principle. You might also hear this called the active personality principle. Basically, this means a country's laws can kind of follow its citizens wherever they go in the world. So if you're a citizen of, let's say, France, and you do something illegal while on vacation in Thailand, France can still prosecute you for it when you get back home. Okay, now for a really controversial one. Tool number 3 is the passive personality principle. This is where a country claims jurisdiction not because of the criminal's nationality, but because the victim was one of its citizens. And for a long, long time, people hated this idea. I mean, think about it. It creates a ton of uncertainty. How could you possibly know the laws of every single country just in case you might accidentally harm one of their citizens? It puts an impossible burden on people, so you can see why it wasn't very popular. So what changed? Well, terrorism, basically. This principle started getting accepted as a tool to fight international terrorism. Take the Yunus case. Here you had the US prosecuting a guy from Lebanon for hijacking a Jordanian plane in Beirut. So what was the U.S. connection? A few American citizens just happened to be on that plane, and the court said, yep, that's enough. And that decision really cemented this once controversial idea as a key weapon in the fight against serious international crimes.
All right, on to tool number 4, the protective principle. This one's all about protecting the state itself. It says a country has jurisdiction over stuff that happens abroad if it threatens its fundamental security. We're talking about things like someone in another country printing fake US dollars or people plotting against the government from outside its borders. And that brings us to our last and, honestly, most powerful tool, the universal principle. The idea here is that some crimes are just so awful, so heinous, that they're considered an attack on all of humanity. And because of that, any state in the world can step in and prosecute. It doesn't matter where the crime happened, who did it, or who the victims were. We're talking about the absolute worst crimes imaginable. Piracy on the high seas, genocide, war crimes, things like that.
And if you want a powerful example of this in action, look no further than the 1961 trial of Adolf Eichmann in Israel. I mean, think about this. Israel prosecuted him for his role in the Holocaust, crimes that happened entirely outside of its territory, against people who weren't its citizens, and before the state of Israel even existed. The court's argument was profound. It said that a crime like genocide harms the entire world, and so any nation has the right, and maybe even the duty, to bring the perpetrators to justice.
Okay, so let's move on to Section 4. We've just laid out 5 different tools a country can use. So what happens when they overlap? You've got a situation where everyone wants to be the judge. Now what? Let me give you a quick scenario. A French citizen commits a crime in Spain, and the victim is an American. So who gets to prosecute? Well, Spain can, based on territory, France can, based on the criminal's nationality, and the United States can, based on the victim's nationality. Suddenly, you've got 3 different countries, all with a legitimate legal claim over the same single crime. So how do you untangle that mess? In the real world, it often boils down to something really simple. Who actually has the suspect? You know the saying, possession is 9/10 of the law? Well, in international law, it's pretty close. The country that has the person in handcuffs is usually the one calling the shots on who gets to hold the trial. Now, the official way they handle this is through a process called extradition. That's when one country hands a suspect over to another. But there are some major rules to this game. First, there's double criminality. The thing they did has to be a crime in both countries. Then there's double jeopardy. You can't punish someone twice for the exact same offense. And critically, there's a human rights protection. No extradition if the person is at risk of being tortured or treated inhumanely. All right, that brings us to our final section, and it's a big one. Section 5, the immunity shield. This is kind of like the ultimate trump card that can beat all the other rules we've just talked about. So we're talking about state immunity. At its core, the idea is simple. You can't sue a whole country in your own courts. But it's not that simple anymore. We've moved away from absolute immunity. Now, there's a really important distinction. For sovereign acts, that stuff only a government can do, like, running its military. The state is immune. Can't touch them. But for commercial acts, stuff a regular person or company could do, the state is not immune. So if a country's national airline buys a bunch of planes and then doesn't pay for them, oh yeah, the plane manufacturer can definitely sue them. That's just business. So let's wrap this up with a big question to chew on. Should extradition of wanted persons be permitted in international law? I mean, we've seen how it's supposed to work, right? It's a tool to make sure criminals can't just hop over a border and be safe. But at the same time, it's loaded with legal complications and real human rights concerns. It really makes you wonder, what's the right balance between chasing justice across the globe and respecting a country's right to be its own sovereign power? And honestly, there is no easy answer to that.